Hi, I'm Danielle Dietrich, and today I'm going to talk to you about some additional changes to the Disadvantaged Business Enterprise or DBE regulations that were released. Today's topic is the changes that they implemented regarding findings of social and economic disadvantage. So it's always been the case that certain groups that have been historically discriminated against are presumed socially and economically disadvantaged for purposes of qualifying for the DBE program. And that's a rebuttable presumption. So it doesn't mean that everybody automatically gets the presumption based on being group members. And so over the years, there have been some issues with different certifying agencies questioning individuals about their membership in those groups. And that has historically been a problem for certain folks. And so the updated regulations make that process clear as to what exactly is supposed to happen. So, under the regulations throughout the history of the program, individuals such as women, Black Americans, Hispanic Americans, Native Americans, Asian Pacific Americans, or subcontinent Asian Americans are rebuttably presumed to be socially and economically disadvantaged. So now the updates to Section 26.67 make it clear that certifiers may not question claims of group membership as a matter of course. There were some out there that were. They also may not impose a disproportionate burden on members of any particular group. So they couldn't, for instance, put more of a burden on Black Americans to prove their group ownership. And this is a reaction to things that have unfortunately happened in different areas. Now, if a certifier has a well-founded reason, now that's the direct words from the statute, to question an owner's claim of group membership, the certifier must now email a written explanation of its reasons to the owner trying to qualify as a member of that group. And that email must tell the owner that they have to provide evidence that they've held themselves out publicly as a member of that group for a, quote, long period of time, end quote, prior to applying for certification, and that the relevant community considers that individual a member. So that is the specified burden of proof, whereas before we really didn't have much. And now we also have this long period of time, which is a little bit of a gray area because that is not defined. And so we could potentially see some issues that arise from that. Now, after this email goes out, the owner has 20 days to provide that evidence. And then the certifier has 30 days to make a decision. If the certifier determines that the owner has not met the burden of proof showing group membership, it must issue a written decision specifically referencing the evidence of record that it relied upon and give a detailed explanation of why the evidence was insufficient. It must also let the owner know of the right to appeal to the USDOT if they disagree with the decision. So this new process helps deal with what has at times been a pervasive problem around certifying agencies. And so setting forth a specific process is definitely a step in the right direction and will hopefully help protect individuals from going through the unnecessary expense, time, and stress of their ethnicity or their gender being questioned. So if you'd like to hear more, please like and subscribe, and I look forward to providing future content.